Hello, everyone. Welcome to our webinar today. My name is Cliff Davis. I'm a shareholder here with the firm of Roberts, Markel, Weinberg, Butler, Haley, and we're going to talk about your governing documents and tuning up your governing documents. And so we will jump right into it. I want everybody to keep in mind that during this webinar, you can type in questions using the Q&A function in Zoom. And if there's enough time, I'm going to read and answer as many of those questions as I can. So some of the things that we are going to talk about today will be understanding the hierarchy of your governing documents, knowing generally when you need the approval of members to amend the document or who can amend the documents. We'll try to fill in the gaps of other dedicatory instruments. And dedicatory instruments is a general term that includes all types of an association's governing documents. It's a term that's defined in the Texas Property Code. So it includes your deed restrictions, bylaws, articles of incorporation, rules and regulations, and every type of policy. Also going to talk a little bit about rules and policies, and some of those are required by state law, and then some might be recommended by council, and then there'll be some that just the board thinks that maybe they need to address an issue that that specific association is having with a policy to clarify how that issue will be handled. So we'll go first talk about, like I said, your dedicatory instruments, which is all of your kind of a global term for all of your controlling documents, all of your governing documents. And typically when an association is formed, there's really three types of documents that start that formation of that. One of those is the plat map. And what the plat map is when the developer has a tract of land, they then divide it up into lots and streets, and they file a map of that called a plat map with whatever county that subdivision is located in. And a lot of you refer to properties by address. The plat map contains what's called the legal description of the property. And you've probably seen that where you see lot 2, block 1, and the name of the association. That's the legal description, and that comes directly from the plat map. The restrictions are another document that's created and filed with the county, like the plat map, before the first lot is sold. And that's called the covenants, conditions, and restrictions, or declaration, or deed restrictions. Those are all kind of interchangeable terms. And then the association itself is set up when the developer files what was previously called articles of incorporation. It's now called a certificate of formation, and that establishes the association as a nonprofit corporation, which is the way most associations are established in the state of Texas. So those three documents get filed, and those are filed with the county. The articles are filed with the state, but they should also be filed with the county in which the subdivision is located. And those are all there in place when the first person buys their lot. And the law, state law, the property code says that when you buy a lot, you buy it subject to all of those governing documents, whether you see them or not. It's a property owner's duty or their obligation to find out what documents affect their property when they buy a piece of property. And just kind of to clear up something that we hear a lot is we hear people say, well, you signed the deed restrictions when you closed, or you were given a copy of the deed restrictions when you close. So nobody ever signs the deed restrictions when they close. If there's no requirement that a title company or a lender or whoever provide you with copies of these documents. Some title companies will give them to you, usually with a caveat that this may be all of the restrictions or it may not be, but sometimes you'll get that, sometimes you won't. Another of the initial documents are the bylaws, which the developer also creates. Bylaws also should be filed with the county in which the subdivision is located. And the bylaws are the administrative rules of the association. So they speak to things like how many people are on the board, what are the terms of the board members, what are meeting notice requirements, and speak to all those administrative type things, which a lot of those are now governed by statute anyway, but the bylaws usually contain all of that type of information. In some instances, bylaws may contain restrictions, but that's really more the exception than the rule. The bylaws usually stick to administrative type issues. And then there may be other documents that are filed out there, architectural guidelines or builder guidelines, rules and regulations that, as we're going to talk about, can cover all types of areas. And again, just keep in mind that if you have a rule, regulation, a guideline, a bylaw, by law, it is not effective until it is filed with the county in which the subdivision is located. So you should not be and cannot be enforcing any rules that are not filed of record in your county. And then there's also federal and state and local law that may govern associations or may have play some kind of role in associations. Federal law might be the Fair Housing Act and how that applies to associations. State law obviously is the property code, which, like I said, the primary law governing associations in the state of Texas is Chapter 209 of the Texas Property Code, also Chapter 202 of the Texas Property Code, and for Harris, Montgomery, and Galveston counties, Chapter 204. So it's chapters 202, 204, and 209, and 204 only applies to some very specific counties. So we'll talk a little bit now about amending your documents. And this is really just kind of what is the general rule? Always when you want to amend your documents, the first thing you need to look at is your document to see what amendment language is contained in that document. But to amend the Articles of Incorporation or your Certificate of Formation, same thing, you typically need 2/3 of all members to approve an amendment. Amendments to the articles or the certificate is somewhat rare. That may arise when, for example, your articles say that you don't have to be a member of the association to be on the board, and the association decides, you know what, we want to require that all of our board members also be members of the association. So you would look to your articles to see if they have a requirement for board members, and if it says that you don't have to be a member and you want people to be a member of the association, you would amend your articles to put that requirement in there. On deed restrictions or the declaration for single family, it is going to be 67% of all owners by statute, or if the declaration contains a lesser number, it's the lesser number in the declaration. So the purpose of this law was to try to make it a little bit easier for those subdivisions, those associations where their deed restrictions required 75% or 90%. By statute now, it's lowered to 67%. But like I said, if your declaration says it's 51%, the lower percentage controls. Condominium, same thing. By statute, it's 67% or a greater percentage if that's what the documents say. The bylaws, typically the bylaws will state, or the articles may also state, how the bylaws can be amended. And a lot of cases it says that the board can amend the bylaws, and then there are a lot of bylaws that say that the owners can amend the bylaws. However, we believe that there's a provision in the Texas Business Organizations Code that gives the board the authority to amend the bylaws, and that would supersede the bylaw amendment language if it's only reserved to the owners in the actual bylaws. And there's a few exceptions to that, and you can talk to your attorney about if you're in one of the exceptions where the board cannot amend the bylaws. So that's something to keep in mind. And like I said, the bylaws are the administrative rules. So really, unless you're trying to do something funny with the bylaws, an owner should not have a problem with the board amending those. And if the board can amend them, the board can address changes in the law and address issues that are administrative in nature, not necessarily rules and regulations on how an owner can use their property. Architectural and builder guidelines, those and rules and regulations, those are all typically have the amendment authority is in comes under the purview of the board. So the board can amend those things without an owner vote in most cases. And again, always look first to what your declaration says on it may address how certain rules and regulations can be adopted and amended, but generally the board has that power. Policies. So we'll talk a little bit about policies. In single family, there's maybe policies that are required by the declaration. There may be policies that are required by state law. And the three big ones that are required by state law is if you have a subdivision with more than 14 lots, the law requires that you adopt payment plan guidelines. And the law says that you have to offer a payment plan of at least 3 months. Doesn't set a maximum number. Initially, this law said it had to be at least 3, but no more than 18. Nobody could figure out why the state legislature would care how long an association let somebody pay off what they owe, and so they remove that maximum requirement. We do see that a lot of payment plan guidelines still contain that. If they do, it's really not effective, as the law doesn't set that limit anymore. A document retention policy. So this policy, and again, this applies to subdivisions with greater than 14 lots. The document retention policy lays out how long you have to keep certain association documents. For example, your dedicatory instruments, you have to keep those forever. Other things, there may be a 4 or 5 year or a 7-year limit on how long you have to retain those. And we encourage associations to really kind of go through their records and not necessarily keep 20 years worth of records. And the issue with that is if you happen to get in a lawsuit and somebody says, I want to see your board meeting minutes for the last 20 years, and you have those, you're going to have to produce those. If you only keep them for what the law says, you only have to produce those records for whatever they may be for the length of time that the law says that you should have retained them. Another required policy for all association is an open records or a document access policy. And again, these things are all controlled by statute, and the policies generally recite what is in the property code, but the law does say that they have to be adopted. These 2 of them if you're more than 14 lots, and all 3 of them for all associations. So there's other types of policies out there too, and I'm sure that a lot of you have worked with some of these. There can be a collection policy, a solar energy policy, solar energy devices, display of religious items, flags and flagpoles, rainwater harvesting devices, generators, and the zero-scaping policies. Those that I just mentioned are also controlled by statute. So you can't stop people from having some of these things, but if you have a policy in place, you can regulate it. You can regulate them. If you don't have a policy in place, you're going to be hard pressed to regulate some of these items of the list I just read. So, you know, the display of religious items, the comment I would make on there is that that law was targeted at a specific type of religious item, and it really is talking about religious items that can be affixed to the doorway of a residence. So that's not something that can control all religious displays, and the statute is even named they call it certain religious items, and it's really a targeted law at one specific type of religious item. Another type of policy you might want to have is a deed restriction enforcement policy that kind of lays out the process the association will go through on a deed restriction enforcement matter. A fining policy where you can fine owners for violations of the restrictions or the governing documents. But something you have to keep in mind is we believe that you cannot fine owners for violations unless you've got some language in your governing documents that gives you the authority to do so. And that may be where your declaration says the association can fine people for violations or establish penalties for violations. But we would prefer that if somewhere in your governing documents you have that authority to levy fines, and again, it may say use the word fines, it may not, but that's something that you would want your attorney to look at your governing documents and say, do we have the authority to fine people? If you're have private streets in your neighborhood, or you have a clubhouse with a parking lot, you may want to have parking and towing policy that talks about how owners can and can't park. You know, if you have a clubhouse, you may not want cars there overnight. So you would need to put some parking rules in place. And also in those rules may include when and if a car will be towed. And then you enforce those rules. The board adopts those and you enforce those. Rental policy agreement, that may be something for your clubhouse if you rent that out, to have a policy and to have an agreement in place that addresses all types of issues of when and how much an owner can use that and what deposits are required. So these are all different types of policies. And you know, it's really, you can use your imagination. This next slide has a list of other things. If you have employees, an association that directly employs people, you may want to have an employment manual. A board member code of conduct will set out the expected behavior of board members. So there's a number of things that are out there that you can adopt to try to address things. Leasing is a very hot item, especially short-term rentals. There was a Supreme Court case that seemed to indicate that the restrictions have to be, or that indicated that restrictions have to be very specific if you're going to prohibit short-term leasing. There's another case that recently came out that indicated that counties that the Chapter 204 of the property code applies to the board can adopt some short-term leasing rules. So that law is in kind of a state of flux, and we're aware of another case that's kind of working its way up the system about an owner that bought property for the purpose of leasing it. And despite a specific prohibition on short-term leasing that was then put in place after she bought the property, she's arguing that you can't change the rules on her after she bought that property. We expect that case is going to an appeals court and may end up in the Texas Supreme Court as well. So for leasing issues, you really need to talk to your attorney and kind of see what the current state of the law is and what you can and can't do. We'll go on to the next one. Single family, here's a couple more camera policies. So we have a lot of associations that contact us and they want to put in cameras at entrances and exits of the association, and just at least have a record of what vehicles are coming in and out of the association. And the issue there may be that owners may constantly contact the association and say, hey, I need to see if my car went out on this date because my son, wasn't supposed to have the car and he did. And in order to prevent an association from being deluged with these records requests, because the camera footage is an association record, we can put in place a policy that says the only people that we will give camera footage to is law enforcement or under a court order, to try to avoid all these constant requests for people who are trying to see who's coming in and out of the neighborhood. So that's a policy that's out there. An election policy can set out how you will conduct your elections. If your bylaws are not specific enough or somewhat ambiguous, you can address these things through policies. So we're going to go in a little more detail on the deed restriction enforcement and fine policy. And as you all probably know, the final step typically in a deed restriction enforcement action is sending a 209 letter, and that is a reference to Chapter 209 of the Property Code, which has a 209-006 specifically, that states that before you can suspend an owner's right to use a common area, file a deed restriction lawsuit, charge an owner for property damage, or levy a fine, you have to send a letter that complies with Section 209.006 of the Texas Property Code. And that has some very specific language in that letter that's required. And we'll talk about that on the next one. Let's see, can we go back one, Kyle? Oh, I'm sorry, number 11, that's good. You can go to the next one. And the demand letter, that 209 letter is what we call it. In this case, it would be a 209 violation letter, because as we're going to talk about in a minute, there's also a 209 collection letter that's required that has a little bit different language. But on a violation letter, your letter has to describe the violation, state the amount due, and if it's a violation that is ongoing and can be fixed, for example, if somebody's got a car in their front yard with no tires on it, you have to give the owner a reasonable amount of time to cure the violation. And if you're going to levy a fine, you have to tell them that you've got a reasonable amount of time to cure the violation and avoid that fine in that letter. And you have to notify the owner that they're entitled to a hearing before the board and that they may have some special rights if they are on active military duty. So those are all statutory requirements that have to be included in that letter. That letter should also inform owners that if they don't fix the violation within the time you state, that they're going to be responsible for all attorney fees and costs will be charged to the owner related to the association's attempts to seek compliance with the restrictions. So that kind of outlines the requirements of a 209 letter. And that's something that should be addressed in your deed restriction enforcement policy of how that process will work. And typically before you send the 209 letter, you're going to send a friendly letter maybe that says, hey, can you get that car with no wheels out of your front yard? And the second one may be, we really mean that you need to get that car out of your front yard. And then the third letter may be the 209 letter, which really what the 209 letter is doing is setting the association up to turn the matter over to the attorney. And then the attorney will send a letter that starts talking about litigation if they don't fix the violation. Something to remember with fines and deed restriction violations is that the law now kind of separates violations into two different types. And the wording is a little awkward. One is called a curable violation, and that's a violation that's ongoing, that can be fixed. For the example I gave you of the car in the yard is something that's ongoing, it can be fixed. There's another type of violation called an uncurable violation, and that really refers to a one-off violation that has occurred, but it's not continuous. And we give some examples there of shooting fireworks, or you've damaged some property, or you've held a garage sale on one weekend, but you don't do another one. And if a garage sale was in violation of the restrictions and you had fining authority, you could fine them for that, but first you have to send a 209 letter. Now, obviously, the difference is you can't give them an opportunity to cure a violation that's not ongoing. So that's the reason why the legislature separated out those two types of violations, because the law as originally written didn't really give you an effective way to address these, what are now called uncurable violations. And here's some examples of curable violations. Like we said, ongoing parking violations, maintenance violations, painting your house would be one of those. Failure to construct improvements in accordance with approved plans. So if somebody builds something that they weren't supposed to, or they didn't build it as approved, that's a violation that can be fixed. So those are a few examples of curable violations. The collection policy is another policy that we generally do recommend that you have. And again, it sets out the process by which you're going to collect the amounts that are due to the association. And typically that would include the due date, a notice that all costs of collection are going to be collected against the owner. Typically for collections, associations also have a process that usually starts within November or December. The association sends out an invoice that has the next year's assessment, but also has all the previous amounts that are due on it. And then in February or March or springtime, the association sends out a letter saying, hey, we haven't got your payment. You need to pay us. And sometimes that letter may be the 209 collection letter, or that may come in a third letter. And the 209 collection letter, like the deed restriction 209 letter, has to have some specific language in it. And I think we talked about that on the next one. And that 209 collection letter has to state each delinquent amount and the total amount of the payment to make the account current. It is our recommendation that that include an itemization of every charge, and that you not group charges in that letter. We believe that it should have an itemization as opposed to a grouping of charges. The letter also has to describe the options the owner has to avoid the account being turned over to a collection agent, which is the attorney, including the availability of a payment plan. So if you remember, we talked about associations with more than 14 lots are required to have a payment plan. In your 209 letter, you have to tell them a payment plan is available to you. And if you ask, you get that payment plan. And the payment plan will be per the terms of your payment plan policy that you've already have filed with the county. You have to provide the owner 30 days from the date the owner receives the notice to pay the amount due. And if you send that 209 letter and the owner does not ask for a payment plan, doesn't pay you in full, it's at that point where the association can then turn the account over to the attorney's office for collection. And so it's very important that these letters get sent, these 209 letters. If you don't send them, an owner can challenge your lawsuit. An owner can challenge any attorney fees you're seeking in that lawsuit, or even not even just a lawsuit, just for the letters that the attorney sent. If you haven't sent a 209 letter that complies with the property code, your attorney fees are at risk of not being able to be recovered. I mentioned on that list too that if you're going to suspend use rights, you have to send a 209 letter. A lot of associations include the suspension of use rights language in their 209 letter, or that can be sent as a separate letter. As a separate letter, if you're going to send it, you have to send a 209 letter that has all of the requirements that we've talked about, plus inform them that their use rights will be suspended if they don't pay within 30 days. And that's usually a big motivator for people who intend to use the pool, who have kids who want to use your pool when that time comes. So we'll talk a little about condominiums. These are some policies that we recommend for condominiums. I think maybe the most important of the would be the insurance deductible policy, which is something that's governed by statute, but the statute also talks about that you can have a policy that, and typically what you're addressing in the policy is how the deductible is handled and who has to pay for that, and when an owner is responsible for a payment of the deductible, or when more than one owner is. So it's important that you have an insurance deductible policy. Another one that is very helpful to condominiums is a maintenance matrix. If you have any experience with condominium documents, sometimes it is just simply not clear as to who is responsible for what maintenance. And your attorney should be able to look at your declaration and draft a maintenance matrix that addresses specific maintenance items and states who's responsible, and then states the authority from where that responsibility is coming from. So some condominiums want to require all their owners to have proof of insurance. Typically in a condominium, the association has to insure the buildings, but if an owner starts a fire within their house, hopefully they have insurance to recover their personal belongings. And that insurance may also play an effect on paying for rebuilding that building, especially if that affects neighboring units. So these are some policies that we do recommend for condominiums. If you have any questions on those, you can contact us and we can either update what you have or create a new one if that's what you think that your association needs. And again, this is I kind of went over this a little bit, the insurance deductible policy. You can review this slide for really why it's important to have an insurance deductible policy. So we're already at the end. That'll seem pretty quick. Again, really what you want to do is have, if you start adopting policies, is make sure they're organized and well thought out. We caution people against policies that contain intricate detail. And let me give you an example is sometimes we'll have an association say that the board drew up this policy for collections, and it'll say, on February 15th, we will send this letter. On March 10th, we will then do this. On April 1st, we will then send the file to the attorney. Well, the problem with that is over time, it's our experience, is that the association ends up violating its own policy. It doesn't send out the letter on the date stated in the policy or sends it out before that. So really, you want some generality in these policies so that you don't trap yourself into violating your own policy. And if you have policies, we think they should be reviewed periodically to make sure there has not been changes in the law, or to make suggestions or to update them, generally update them. We believe that you need to tune up your documents, at least maybe once a year, just have your attorney take a look at them. And these are generally, we're talking about the policies or the documents that the board can amend. The declaration, always we can make recommendations, but the declaration is in 99% of the cases going to require a vote of the owners that we talked about. And one thing to definitely avoid is you get your hands on a policy from another association and you say, this looks good, you cut and paste it and put it in a policy and file it. And that can lead to trouble because the language in another association's policy may be based on language that's in their declaration, in their deed restrictions, and you don't have that same language. So what you think looks like a good idea for you really doesn't apply because you don't have the authority to do that, or your declaration may contain something that's in direct contradiction with what you're seeing from another association. So be careful about cutting and pasting, but don't be afraid to look at your policies and have your attorney take a look at them every so often to make sure that they're updated and in compliance with the law. We're going to give you just a quick legislative update. Right now, we're really kind of just watching two bills. One of those has to do with condominiums, and it has to do with open records requests in a condominium. And really what this looks like it is they're going to put the same standards that now single family associations have to follow in producing records. And there's a very specific procedure, and this bill's been introduced. so that condominiums will more or less be under that same requirements when someone makes an open records request. And it sets a deadline for when you have to respond and how you can charge the owner for those records and what happens if you can't produce the records within the 10-day deadline. It'll all be laid out in a statute if this passes. The other statute we're watching is one that will give associations the authority to remove discriminatory provisions without having to get a vote of the owners. As some of you may or may not know, there are older restrictions out there that contain racial restrictions that state that certain persons can't buy a property in the subdivision. And it's been difficult for a lot of those associations, especially subdivisions that don't have an association, to amend those documents. And the purpose of this law will be to allow the board or a small group of owners to go in and remove those discriminatory provisions, which are outlawed by federal law and state law, but they're still there on the books. And it's disconcerting when you see racism in a document that at one time was sanctioned by the government. And so, if you have those, if you've got an older subdivision, you want to remove those if you can, and this law will make it a lot easier to do that. We're going to go to question and answers now. We've got some pre-submitted questions, and I'm going to go over those, and I see that we've also got some that are people have been writing in, and we will go over those too, as many of them as we can. So first question is, aside from deed restriction bylaw amendments, what about more customized association policy and board preferences while working with a management company? Again, that's something we talked about. There's a list contained in this PowerPoint, and there may be something that a board is having an issue with that's not on that list. And that's something where you need to work with your management company and your attorney to say, this is our specific problem. Do we have the authority to adopt a policy on it? And that authority is going to either come from your governing documents or from state law. And if so, let's work to make a policy that fits for us. If the property code changes or federal law dictates, and the declaration says something other than the law, must the association amend the documents? And the answer to that is no, you don't have to amend your documents. The law is going to supersede what's in your documents. However, if you update your documents, you should amend them to bring them into compliance with the law. This really is true. What I see mostly is in bylaws. Most association bylaws need to be amended and restated. A lot of them have old concepts in there. A lot of them have, the requirement of a corporate seal, which nobody uses. A lot of them talk about nominating committees. And now that the law requires any association with over 100 lots to solicit candidates, you don't really need a nominating committee. And the ones that have that nominating committee are usually not following it, from what I see, because it says the nominating committee shall be appointed at the end of the annual meeting and serve to the next annual meeting. A lot of them never appoint a nominating committee. So just remove that stuff. A lot of that can come out. Most older bylaws say that you can suspend voting rights for people that are delinquent. That is against the law. You cannot suspend voting rights. So that, that needs to come out, and that can come out by amending and restating your bylaws. And like I said, don't be convinced that you can't do it just because your bylaws talk about an owner vote and you don't think you could ever get an owner vote. There may be a way around that using the Texas Business Organizations Code. So this next question and comment says, the state of Texas is allowing Airbnb and similar companies into HOAs. City of Austin is fighting that stance to try to allow HOAs some semblance of control. And then the question goes on to talk about group homes are being introduced in the same HOAs under the guise of Airbnb. So there's a number of issues raised in there. First, I don't know that the statement that the state of Texas is allowing Airbnbs into HOAs is accurate. That may be a reference to the Texas Supreme Court case I talked about. And just to give you a little more detail, in that case, the applicable deed restriction said that you can only use the property for residential use. The owner was renting out the property, had rented it out like 30 times over a span of 3 months, and there were short-term rentals. And the Texas Supreme Court, another kind of important fact is that owner was paying the Texas hotel occupancy tax, which would make you think that's a business use. The Texas Supreme Court said that's not a business use, that people come into this, they live, they eat, they watch TV, they use it like any other resident uses their property, and that use was a residential use. Now, that was based on the specific wording of those restrictions. So if you've got more specific, more detailed wording, if your deed restrictions say minimum lease term is 6 months or goes into more detail, you can prohibit these short-term rentals or certain types of leasing. This comment also talked about group homes, and group homes are kind of a general term for living situations where there may be a group of handicapped people living in a home in the middle of a subdivision. And those people, the handicap may be visible, it may be a physical handicap, and sometimes it may not be visible. That type of living is protected under federal and state law, under fair housing laws. And you cannot enforce a single family only restriction or a no commercial use restriction against those types of living arrangements if they are one that's protected under fair housing. And I won't go into too much detail, but generally, if you see that situation, the first step you need to do is try to figure out what is going on there, what is the living arrangement, and who are these people. But you have to be very careful about how you do that. So if you just fire off a letter saying you're in violation of the restrictions, that can be seen as a discriminatory act. So you need to figure out what is happening there and then determine if it's a protected use. And this is something that it's hard for a lot of boards to swallow because they just don't think that it should be allowed and they think it's a violation. But again, if it is a protected use under the law, you cannot pursue that type of violation. Now, if you've got a group home and they start adding on rooms in the front of the house in violation of the setback, you can address those issues. Those group homes still have to comply with those types of restrictions, but it's the use restrictions that they have some protection from. So what is the line between a board decision and when we need to go to the community for a vote? Well, the one obvious line is in the declaration, where that's more than likely going to take a vote of the owners. Typically on the bylaws, you may have authority for the board to amend, or in policies, you may have the authority for the board to amend. But there may also come a time when, the owners want something that the board is not necessarily in favor of, and the board can make that decision. But instead, they decide, here's what we'll do is we'll put it to a vote of the owners and we'll do what they want us to do. So that's really a line that sometimes will have to be drawn by the board, is even if we have the authority to make this change, is that something we want to do? Or do we want to have the owners vote on it? And then we can say, when somebody protested, is we took a vote and that's what the owners decided. So that's really a line where that you need to draw for the specific circumstances of what your association is going through. This one's got a few questions. What options does the board have if residents refuse garbage pickup services and pile trash in front of the house for weeks? Well, you have to see if you have a restriction that you can enforce to address that kind of behavior. And you may have a specific restrictions that says you can't let garbage or trash or rubbish, you can't keep that in view on a lot. You may have to rely on your nuisance and annoyance provision to say, the condition on your property is a nuisance and annoyance to your neighbors. When you rely on that provision, we would always prefer that you actually have neighbors that have submitted a complaint in writing to you about whatever that condition may be. And in writing can also mean by email. But sometimes it's hard for a board to say, well, that's a nuisance annoyance, but there's no real adjacent neighbors complaining. So always look for neighbor complaints if you want to call something a nuisance and annoyance. What options can be used if residents dump trash in dead-end streets? Again, it depends. If those are association-owned streets, you have rulemaking authority, you can pursue that. If they're county streets or city streets or whatever governmental controlled streets, you need to find out who's doing it, get evidence if you can do that without any risk of harm to yourself, and then report it to your county commissioner or to law enforcement. Those all sound like criminal violations of doing that. What options are available when a homeowner files bankruptcy and does not pay fees, but uses a community property, including the pool? So bankruptcy is a little tricky. We generally recommend that you not try to suspend an owner's use rights for the pool when they're in bankruptcy. whether it's for amounts that came due before they filed bankruptcy or for amounts that came due after the bankruptcy filing, unless you go to the bankruptcy court and get permission from the court to suspend those use rights. Bankruptcy judges don't like associations suspending use rights unless they said it's okay. So that's just kind of a thing you have to deal with when people are in bankruptcy. How can amendments and articles be amended or new ones added? We've talked about that a little bit in the PowerPoint, and I hope that your questions were answered. Is there a way for participants to get hard copies of these seminars? So if you have registered for this seminar, you should be being sent a copy of the seminar after it's over with. If you have missed some in the past that you think you want to see, you can go to our website, rmwbh.com. There's a publications tab, and then there's a webinars tab, and all of our past webinars are available online. Again, our website is rmwbh.com. That is all the, oh, one more from this list. Can more than one board member from the association attend these? Yes. Anybody who registers can attend these seminars. So I've got some questions submitted in the Q&A. We've got a little bit more time. Is the title company responsible to provide the dedicatory instruments to the buyer? I think we went over this. They are not required to do that. A lot of them make an attempt to do it, but they don't necessarily provide all, and they may have a caveat saying, this is what we know of, there may be more out there. So this one says, I heard you say 2/3 of the vote was typically needed, but you stated there are circumstances where the board can decide on their own. Please restate circumstances when the board can amend bylaws without a 2/3 vote of the owners. Okay, so first off, when you're going to amend the bylaws, first thing you need to look at is your articles of incorporation or your certificate of formation to see if it dictates who can amend the bylaws. And typically that will say something like only the owners can amend the bylaws, or it may say the board of directors can amend the bylaws. The next thing you look at is your bylaws themselves, which will have an amendment provision. And it may say that it takes a majority of the owners or 2/3 of the owners to amend the bylaws. Now, if it has that language, like I said, we believe there's a provision in the Texas Business Organizations Code, it's section 22.102, that allows the board to amend the bylaws unless there's one of the exceptions in there. And one of the exceptions is if the articles of incorporation say that only the members can amend the bylaws. So it really depends on what your documents say. It's something you should consult with your attorney about or call us about, and we can advise you on if we think the board has the authority to amend the bylaws despite the amendment language in the bylaws. Requesting individual insurance policy for condominiums. What are the guidelines? Excuse me. It really, I guess I'm not really clear. So we have some associations that require owners to have insurance on their property that's sufficient to cover whatever that is. And it's really something that depends on the unit, the value of the units. And it's something that we can work with the board and the board's insurer on if you want to develop that kind of policy. Is there a communication policy using emails or text as a form of communication? So with regard to communication, I guess I'm not really sure what you're asking, but most boards do a lot of communicating by email. Boards have the authority to make decisions by email votes, except there is a list of 15 items. And if a board's going to vote on those, it has to be in the open session of a properly noticed board meeting. But generally, yes, you can communicate by text and emails if you're on the board. If you're asking if you can give notices to owners by text or emails, it's possible if the owner agrees to it. However, the problem that we see with trying to give, for example, meeting notices to owners by a means other than mailing is that, again, the owner has to agree to it and the board has to agree to it. But you can create a record keeping problem for yourself of what owner is supposed to get notice what way. And that could be a nightmare. So we really don't have many associations unless they're very small, under 20 units or under 30 units that have really gotten into giving notice by email. So we think the best way to go still is to give meeting notices by mail. Can you have a parking policy for public streets? The general answer is no. Public streets are controlled by the government. So really a parking policy will be for association owned property, including clubhouse parking lots and private streets. So typically those might be gated streets that the association owns and is responsible for. Does a code of conduct have to be recorded as a dedicatory instruments? We believe the answer to that is yes, has to be recorded. Can you address sidewalk policy? That one is a big question everywhere. You know, a lot of times sidewalks are located in the right of way and not on a person's property. And so the person, the owners, when you write them a letter, says, that's not on my property, I don't have to fix it. Well, hopefully your deed restrictions specifically address that issue. So the deed restrictions can say that you have to maintain your sidewalk that's located between your property and the right of way and the curb of the street. If an owner calls the county and says, hey, I need you to come fix my sidewalk because my association's written me a letter, the county is probably going to say, that's your problem. You got to fix it if you want. So a lot of times an association is just in the position of having to take the position that sidewalk maintenance is the responsibility of the owner. And you may want to adopt a policy if it's not addressed in your restrictions. So at least when an owner says, where does it say I have to fix my sidewalk, you can point to something in writing that's filed with the county. Now, just because you file a policy doesn't mean that it can't be challenged, but it is always better when you're trying to enforce something on an owner that you can point to the writing that says, you know, what you're trying to enforce. If an HOA does not have a fining policy in place, do they still have to send a letter with 30 days notice for single family and condos? Can the board determine the time to cure, or does it have to be 14 days? So the 209 letter does not apply to condos. Chapter 209 only applies to non-condominium associations. And that may be a traditional single family association, and it may be a townhome association. The thing with townhome associations is some of them are called townhomes, but they're actually condos. And the way you find out the difference is by looking at your declaration. If it's a condo, it will say in the declaration something like it's organized as a condominium regime. So the 209 letter applies to non-condominiums. You still have to send a 209 demand letter, a 209 fine letter that tells the owner, this is your violation. You've got this amount of days to fix it, and you've got 30 days to request a hearing. You don't have to give them 30 days to fix that violation. However, since they have 30 days to request a hearing, most associations just give them 30 days to cure the violation also. So I guess kind of the general point from this question is whether or not you have a fine policy, you still have to comply with Chapter 209 of the Property Code if you're a non-condominium association. Do you have to state how much the fine will be if the violation is not cured? Yes. The Property Code requires you have to state the amount due, so you have to tell them specifically. Did I hear correctly that a 209 letter does not come from an attorney? The property manager can send the 209 letter. The answer to that is yes. In fact, it's really the intent of the law on the deed restriction side that the 209 letter come from the association or the management company as the agent of the association. The reason for that being is, like I said, the 209 letter requires that you give the owner the right to request a hearing. The purpose of that was to try to get the association and the owner to talk together without involving attorneys before an attorney got involved. So most deed restriction violations we get, the association has already sent the 209 letter. There may be cases where, for whatever reason, the type of the violation or the owner involved, the board feels it might be better for the 209 letter to come from an attorney, and we can send those if that's their desire. However, the attorney fees related to that 209 letter cannot be charged back to the owner. You can't charge attorney fees back until the 209 letter has been sent and the 209 period has run, or until the end of the 209 hearing. After that is when you can start charging attorney fees back to the owner. For uncurable violation, would you still go through the process of the friendly letter? I think it says they're trying to say rather than the 209 letter, or would you just send the 209 letter first? And that's a decision, I guess, that the board would have to make. The board may decide, look, they did it once, we'll send them a letter saying, hey, don't do it again. Or the board may decide that this person is a problem, or they've done this before, we're going to just send them straight the 209 letter. So that's really a board decision, and you have to take into the factors of that specific situation. Signs are prohibited in RPOA. Are sports banners considered signs? This is, signs have been a big deal this year primarily because of political signs. And we do believe that a sign is a sign and a banner is a banner. So if it prohibits signs, you may have a problem going after a banner. That might be something you also want to try to address in a policy, that the association will treat these other things as signs. But again, that doesn't mean that it won't be challenged, and a judge may say the declaration says signs, and that means signs. What is the highest interest rate permitted by law a condo HOA can charge an owner for late assessment? So this interest is another kind of a gray area in the law. We generally believe, our recommendation is, unless your documents have a specific interest rate, and that should not be higher than 18%, we recommend that you charge 10%. So if your declaration says you can charge the highest interest rate allowed by law without anything further, our recommendation is that you charge no more than 10%. Can a condominium board decide to take out large loan for contingency purposes without owners voting on it? That all depends on your documents, on what they say the association's authority is with regard to loans. I mean, a lot of them address that specifically. If they don't, the only thing I would tell boards is if you're going to do something that's going to put the association in a financial hole and it's not required that you have an owner vote, you still may want to think about having an owner vote. That provides you with political cover if things go bad in the future. For non-curable offenses, does the association have to send the 209 with a fine, or is the 209 letter a warning letter and a next letter goes out with the fine? Now, this is what I talked about where they changed the law to address this issue. So for non-curable offenses, you do have to send a 209 letter before you fine, but you don't have to give them the opportunity to cure. So the way to comply with the law, I believe, is that they had their garage sale, your declaration prohibits garage sales, you want to fine them for that. So you send them a 209 letter telling them they're going to be fined $200 or whatever your fine amount is. And after the date you send that 209 letter, you then can put the fine on the account, because the law says before you levy a fine, you have to send the 209 letter. So you don't want to put the fine on the account and then send the 209 letter. You want to send the 209 letter and then put the fine on the account. Hopefully that makes sense. Does all of 209 apply to condos? No, 209 does not apply to condos. Condos are generally governed by chapters 81 and 82 of the Texas Property Code. There's a date specific if all of chapter 82 applies. So it really depends on the age of your condominium on if 82 applies, or if it's parts of 82 that are retroactive and 81. Let's see, question going back to restricting an owner from using the common areas. If it is in the community documents that a homeowner loses access to all common areas when delinquent, does a 209 letter still have to go out first? Yes, still have to give the 209 letters if you're going to suspend use rights. The declaration, the language may just authorize you to suspend use rights. It may not state they're suspended, but I've seen both. I've seen where it authorizes you to suspend use rights, or to where it states you are suspended, but you still have to send that 209 letter. What to do when resident refuses to accept certified mail? So he claims there's no 30-day notice after he was notified. Well, our advice is every letter you mail certified should also be mailed by regular mail. So really, most people don't accept certified mail. And really the purpose of that is to prove that the letter was sent. So they can't make that argument if you send regular, because you say, well, you were sent it regular too, and we assume you got that unless it was returned back to you. So that's really not a good argument. And quite frankly, I don't think most judges would fall for that argument. Would the attorney draft a policy if requested? Some boards want to draft their own policies. So it's my experience that it's, and not just to generate business for attorneys, that it's better if you let the attorney draft the policy, or, if you want to present some ideas, the board wants to present some ideas and then send to the attorney to review. A lot of times we find what boards write doesn't necessarily comply with the law. And sometimes for certain types of policies, it costs more to try to fix what a board prepared than just to generate a policy from scratch. Most attorneys have a template that they start with. So boards can write policies, and sometimes we get from a board, we want you to file this. We don't want you to ask any questions about it. We may skim it to see if there's anything crazy illegal in there, but in some instances we will file it if we don't see anything. But we typically will put a stamp on it saying we didn't review this. This is the board's. To confirm, you say that suspending right to vote for owners delinquent is not lawful. That's correct for non-condominium associations. If you have a condominium, you still may have the right to suspend voting rights. Can a board decide to build an activity center without the consent of the owners? It may cost about $150,000 and require a special assessment fee. So, again, that depends on what your documents say. If they give you the authority to do that, my advice would be, if you're going to spend that kind of money, you should have a vote of the owners and get an idea of what they like. And if you're going to have to levy a special assessment fee, the chances are that your governing documents are going to require that the owners approve that special assessment. It's not, it may be that a board has the ability to levy a special assessment without a vote of the owners, but that would be rare if they do. In most cases, the owners have to vote on a special assessment. Must the ability to fine be set in the declaration, or can it be defined in other governing documents? We believe the best authority, and the authority that's subject to really not being challenged, is if it's in the declaration. We prefer that it be in the declaration. You can maybe try to put it in your bylaws. If you do, you should note that that might be subject to challenge, and a court could say that putting fining authority in the bylaws is really outside the purview of the bylaws. But at a minimum, at best case, it's in the declaration. At a minimum, it should be in another governing document, such as your bylaws. But a court may not look kindly on a board voting to give itself the right to fine owners that's not contained in the declaration. If the restrictions state that the board can make policies that contradict the restrictions specific to parking restrictions, is that okay? So it may be that a declaration sets out some parking rules, for example, but gives the board the authority to adopt rules that are in conflict or that expand on those. If that authority is in the declaration, you should be okay. I would really have your attorney look at that to make sure and agree with you on what you think the declaration says. What are the best ways to enforce parking in a small gated community? Parking restrictions and make owners utilize their garages for parking cars instead of storing their stuff. That's a big issue too, is when you've got associations that have small driveways and owners tend to put things in their garage other than their car. Again, if it's a private street, you can regulate the parking on the street. If you want to regulate the parking on the lot, you generally are going to have to amend the declaration. And we're kind of seeing more and more declarations that state that you have to, your garage has to be capable of fitting two vehicles if it's a 2-car garage in it at all times. Can you send violation letters to an account that is with the attorney for collections? Yes. It's about 12:30, so let's do about 2 more of these, and then we will wrap it up so everybody can get on with their day and eat lunch or keep working. If a video camera has been placed on a side wall of a home, which possibly could view through a neighbor window above their patio door. Is this a neighbor and neighbor dispute, or can the HOA intervene? So, we generally try to advise associations to try to stay out of neighbor to neighbor disputes. There's really no winning in those. So, I talked about a camera policy, and I think I just mentioned really for association cameras, some associations are adopting security camera policies, and one of those may be that if an owner is going to install those, they can't aim their camera at a neighboring property. Now, the problem is with cameras is even if you don't aim it directly at a neighboring property, you may be able to pick up activity on a neighboring property. So it's really kind of a slippery slope. If you have a rule in place on cameras and someone is violating it, you can enforce your rule. So, but if you don't have a rule, and like in this specific instance, I just would tell them that's not an HOA problem. That's something that you're going to have to deal with your neighbor. Same thing with leave a bright patio light on all night. You have to look and see if there's a restriction or a rule against light that goes over into the neighboring properties. And if there's not, that's a neighbor to neighbor problem. And if there is a rule, you've got to really think about what your rule says and if it's a violation, and if really all you're getting involved with is two neighbors that don't like each other. If I wanted to find out what governing documents have been filed with the state, where would I find them? We recently switched HOA management companies, and it seems all of our documents have not been transferred. So generally your documents are going to be filed with the county, not with the state. The state will have a copy of your certificate of formation, articles of incorporation, but your other documents will be filed with the county. Some counties, you can have a website you can go on and put in a search using your association name for documents. The problem with that is that when a document gets filed with the county, it gets what they call indexed. And it depends on what name was put in the indexing. So, if you have an association that's the ABC Association and you search that, you may find them. But some documents may have been indexed as ABC ASSOC or ABCA. So it can be tough to locate those documents because you don't know who typed in the indexing information. Now, another option you have is that if you have an attorney, is they should have the capability of obtaining a report from a title company of all documents filed that affect their association. And you still may have an issue with getting everything, but generally the title company has a more robust search and may be able to find all the documents that were filed. Is there a common definition of single family recognized now? No, there's not. And that's been a kind of a subject that's been, courts have not been anxious to address that subject. So it's really something that you have to look at what your restrictions say, look at the living situation, and determine if you think it's a violation. Generally, if it's a family and the owner's parents, we're going to tell you, and an association comes to us and says, that's a single family use violation. We're going to tell them, don't even touch that with a 10-foot pole. But if it's a couple and then a brother and sister and their children, and their spouses, that's when you're walking down the road. That's not really a single family. But again, you've got to really look at your restrictions. So we're at 12:35 now. I think I'm going to end this. I'm going to try to answer some of these other questions with a typed answer, and I'm not sure if you'll be able to stay on and see that, but I believe that when we, and Kyle, maybe you can let me know, when you send out the presentation, do we send out the questions too or no?
Cliff, no, we don't, but I can download the questions and get them to you in case you want to email any of these folks back.
Okay. Okay, I will try to do that and answer the rest of the questions, but I hope everybody got a little bit of information today. I know it's a lot of stuff coming at you fast. And again, you should be emailed a copy of the PowerPoint. And if you want to see this or other PowerPoints, you can go on our website, rmwbh.com. Thanks for coming.